Well, I'd like to thank you all for coming here to Heritage. My name is John Malcolm. I'm a senior legal fellow here in the Center for Legal and Judicial Studies. And I appreciate all of you being here in attendance, and to those of you who are watching online, as we continue with Heritage's Preserve the Constitution series, which is part of our continuing celebration of the 225th anniversary of the signing of that document. In 1789, George Washington wrote a letter to the United Baptists in Virginia, and he stated the following: "If I could have entertained the slightest apprehension that the Constitution framed in the convention where I had the honor to preside might possibly endanger the religious rights of any ecclesiastical society, certainly I would never have placed my signature to it. And if I could now conceive that the general government might ever be so administered as to render the liberty of conscience insecure, I beg you will be persuaded that no one would be more zealous than myself to establish effectual barriers against the horrors of spiritual tyranny and every species of religious persecution." Now, some claim that today religious freedom is under an unprecedented assault, and that religious institutions and individuals are being treated as second-class citizens under our Constitution. And we have an outstanding panel here to debate this topic for the next hour, hour and a quarter. Now, I could take all of our time introducing our panelists. Their resumes are extensive and impressive. I'm going to, however, try to keep this short, and I think, for instance, that you can trust me when I tell you that all of our panelists graduated and got postgraduate degrees from very prestigious institutions. With that, I'll give a brief introduction to each of our panelists in the order in which they'll speak. Right here immediately to my left is Dr. Richard Land. Richard has been since 1988 the president of the Ethics and Religious Liberty Commission. That is an entity of the Southern Baptist Convention that addresses social, moral, and ethical issues and pays particular attention to how those issues affect families and their faith. Prior to that, Dr. Land served as the Criswell College's vice president for academic affairs, where he also taught theology and church history. He also served for 5 terms on the United States Commission for International Religious Freedom, where I used to serve as general counsel. In 2005, Richard was named by Time magazine as one of the 25 most influential evangelicals in America. For many years, Dr. Land hosted a syndicated radio show, and he is also the author of dozens of scholarly books and articles. Next to him is Bill Galston. Bill is the Ezra Zilka Chair at the Brookings Institute, specifically their Government Studies program, where he serves as a senior fellow. He's also a professor and former acting dean in the University of Maryland's School of Public Policy. He's a founding director of the Center for Information and Research on Civic Learning and Engagement, and he's also the executive director of the National Commission on Civic Renewal. From 1993 to 1995, he served President Clinton as a deputy assistant for domestic policy. He is a frequent commentator on National Public Radio. He writes a weekly column for the New Republic, and is the author of 8 books and over 100 articles dealing with public policy and politics, and he is the recipient of many prestigious awards for his scholarship. Jay Sekulow, for over 20 years now, has been the chief counsel at the American Center for Law and Justice, which now, by the way, has international affiliates in France, Russia, Kenya, and Zimbabwe, where they defend religious freedom and human rights around the world. He's the host of a daily radio program and a weekly television program. He also serves on the faculty of Regent University School of Law. He's argued a dozen times before the U.S. Supreme Court, including several groundbreaking First Amendment cases. The National Law Journal has twice named Jay as one of the 100 most influential lawyers. Time magazine once named him as one of the 25 most influential evangelicals in America and called his organization, the ACLJ, a powerful counterweight to the ACLU. He's the author of 2 dozen scholarly articles, including, by the way, an excellent legal memorandum that I hope you all picked up on your way in. If not, please pick one up outside. And to those of you who are watching online, you can access a copy through Heritage's website. And our final speaker will be Professor Marci Hamilton. Marci was a former law clerk to Associate Justice Sandra Day O'Connor, and she is the Paul R. Vercule Chair in Public Law at the Benjamin N. Cardozo Law School. She's been a visiting professor at Princeton University, NYU Law School, Emory University Law School, and at the Princeton Theological Seminary. She's one of the leading scholars on church-state issues and has served as counsel and is serving as counsel in many important clergy abuse cases and religious land use cases. She was the lead counsel for the city of Bernie in the case of Bernie versus Flores, in which the Supreme Court struck down as unconstitutional the application of the Religious Freedom Restoration Act to the states. She's the author of dozens of scholarly articles and several books, including God versus the Gavel, Religion and the Rule of Law. Please join me in welcoming all of our panelists.
Should I speak from here?
Totally up to you.
All right, and how many, 8 minutes? 7 minutes, 6 minutes?
I'd say, 8-10 minutes.
All right. Thank you. I had debates and discussions with many of my colleagues, Baptists and others, over the years about whether or not the real threat to the First Amendment freedoms that we are guaranteed under the Constitution would come from violations of the Establishment Clause or violations of the Free Exercise Clause. And came to the conclusion many years ago that in my lifetime that the threats would be almost invariably threats to the Free Exercise Clause. And unfortunately, I've never been sadder to be proven right, but it seems to me that this is indeed the case. It seems remote to me that there would be any serious threat to the violation of the Establishment Clause in my lifetime. But attacks on and attempts to limit the Free Exercise Clause go on, perhaps the most recent examples being the HHS mandate, where people of faith and people of conscience are being demanded and commanded to subsidize that which they find unconscionable, either contraception in the case of our Catholic friends, or abortifacients, both Catholic and Protestants and some other faiths, and sterilization. And to the extent to which this attempt to change freedom of religion into freedom of worship, which is it's really a sterilized version of religious freedom. Freedom of worship is the freedom to worship as you please in your own church or in your own home, but not to exercise your faith freely and bring it to play on public policy matters. There was a news conference on September the 6th, and there was discussion at this press conference about the Patient Protection and Affordable Care Act, otherwise known as Obamacare. And a reporter asked former House Speaker Nancy Pelosi, one of the services that healthcare plans to offer free of charge under the HHS mandate are sterilizations. Do you agree with the federal government mandating? At this point, Congressman Pelosi cut the reporter off and responded, you know what, I told you before, let's go to church and talk about our religion. Right here, we're talking about public policy as it affects women. Now, this is a clear attempt, and it's systematic, an attempt at censorship of religious convictions in the public square, and an attempt to exercise secularist censorship. It's hard for me to imagine that we've come to the place in America where unless the HHS mandates are rescinded or unless they lose in court, and I do predict they will lose in court if it comes to that, because the federal judiciary is still more familiar with the Constitution than evidently some of our congressmen and some of the people who work in the executive branch are, that people will be forced to either subsidize that which they find unconscionable, or pay a fine for not having health insurance for their employees or for themselves. In the interest of time, I want to say to you that I have with me a copy of a work product that our commission put forth. A former president of our convention, Jim Henry, asked us to document for him the current administration's hostility toward pro-family values, and We did so in a document that is 31 pages long with footnotes, and we'd be glad to share that with you. And if you'd like to have a copy of it, we'll be glad to provide one for you if you'll give me your information. But it's reached the stage now where a group of Catholic, Protestant, and Orthodox ministers, theologians, came together in Manhattan and issued the Manhattan Declaration. And I would encourage all of you to read it. It's an extraordinary consensus document, and I want to quote from it in concluding my introductory remarks. It is ironic that those who today assert a right to kill the unborn, aged, and disabled, and also a right to engage in immoral sexual practices, and even a right to have relationships integrated around these practices be recognized and blessed by law, such persons claiming these rights are very often in the vanguard of those who would trample upon the freedom of others to express their religious and moral commitments to the sanctity of life and to the dignity of marriage as the conjugal union of husband and wife. We see this, for example, in the effort to weaken or eliminate conscience clauses and therefore compel pro-life institutions, including religiously affiliated hospitals and clinics, and pro-life physicians, surgeons, and nurses and other healthcare professionals to refer for abortions and in certain cases even to perform or participate in abortions. We see it in the use of anti-discrimination statutes to force religious institutions, businesses, and service providers of various sorts to comply with activities they judge to be deeply immoral or to go out of business. After the judicial imposition of same-sex marriage in Massachusetts, for example, Catholic Charities chose with great reluctance to end its century-long work of helping to place orphan children in good homes rather than comply with a legal mandate that it place children in same-sex households in violation of Catholic and moral teaching. In New Jersey, after the establishment of a quasi-marital civil union scheme, a Methodist institution was stripped of its tax-exempt status when it declined, as a matter of religious conscience, to permit a facility it owned and operated to be used for ceremonies blessing homosexual unions. In Canada and some other European nations, Christian clergy have been prosecuted for preaching biblical norms against the practice of homosexuality. New hate crimes laws in America raise the specter of the same practice here. In recent decades, a growing body of case law has paralleled the decline in respect for religious values in the media, the academy, and political leadership, resulting in restrictions on the free exercise of religion. Now, it goes on to talk about this some more, but let me just conclude by saying that it seems to me that the spearhead, or perhaps the concise summary description of this worldview, which is very intolerant of religious worldviews with which it disagrees, is summarized by Kai Feldblum in her Georgetown Law School Review article, in which she says that when the beliefs and the rights of people of religious conscience come into conflict with the rights of the gay, lesbian, bisexual, and transgender community, that the rights of the religious must give way. That seems to me to be rather intolerant for someone who is an Obama appointee to the Equal Employment Opportunity Commission. And the extent to which there is a statist attempt to intrude into the internal workings of religious organizations is the Tabor case. The Tabor case, essentially, the Obama administration and the Justice Department were claiming the right to interfere with the hiring practices of religious institutions. Their position was so extreme that they lost 9-0 in the Supreme Court. Now, it's difficult to get the current Supreme Court to agree 9-0 on what time of day it is. But they voted 9-0 against this radical attempt to intrude the federal government into the hiring practices of ministerial employees in a religiously affiliated school. And I must confess I enjoyed John Roberts' succinctness on occasions. And in this case, he said, "I find it remarkable that I'm paraphrasing here. I find it remarkable that the Justice Department would argue that there are no special protections for religion in the Constitution, since the word religion is mentioned twice in the First Amendment.
Well, let me begin these remarks with a disclaimer. I'm a political theorist and a policy analyst, as some of you know. I'm not a lawyer, a litigator, let alone a law professor, although, full disclosure, I am married to one. But because so many of the issues before us are cashed out in legal and constitutional terms, I will, to a very great extent, speak in those terms. And so these remarks will be, so to speak, played on an away court in more senses than one. I should also say that in my own theoretical work, I have cited almost all of the texts that show up in J. Sekulow's legal memorandum, and very much to the same purpose. And I'm deeply sympathetic to the idea of individual religious conscience and maximum feasible accommodation for civil society institutions, religious as well as secular, that have internal modes of belief and practice that diverge from those of the political order as a whole. The question is how far those individual commitments, which I share with many other people on this panel, will take us when we bring them into contact with constitutional and legal reality. To probe that question, I'd like to begin with a famous episode in American history. On October 29th, 1919, the National Prohibition Act, popularly known as the Volstead Act, which created the legal definition of intoxicating liquors and specified penalties for producing it, passed over President Woodrow Wilson's veto and became the law of the land, which it remained for nearly 14 years. Now, the act created a number of exemptions to the prohibition regime, of which one is especially pertinent for our purposes. Its text specified that nothing the act contained should be construed as applying to, and I quote, wine for sacramental purposes or like religious rites. And it permitted the sale or transfer of wine to rabbis, ministers, priests, and officers duly authorized by any church or congregation. Now, as the law professors would say, consider a hypothetical. Suppose the Volstead Act had failed to exempt wine for sacramental purposes. There would have been a political firestorm, of course. There would also have been a First Amendment challenge. Query, would that challenge have succeeded? Now, this is not a peripheral issue. Sacramental wine lies at the heart of more than one religion. The Code of Canon Law of the Catholic Church prescribes that, quote, the most holy sacrifice of the Eucharist must be celebrated in bread and in wine, to which a small quantity of water is to be added. For its part, Jewish law commands the drinking of wine during the Passover Seder, specifying not only the famous 4 cups, but also a minimum quantity per cup to be consumed. As Seder veterans know, there is no maximum quantity specified.
True enough.
Comprehensive prohibition without exemptions would have forbidden faithful Jews and Catholics from acting as their religion requires. This would seem to be a quintessential free exercise case. And yet, when what I take to be precisely this issue came before the Supreme Court in 1990, panelists know where I'm going with this, Justice Antonin Scalia, a famously staunch Catholic, authored a majority opinion holding that the sacramental use of peyote in Native American religious rites did not warrant exemption from drug laws of general application. At the heart of his majority opinion in the famous Employment Division v. Smith case was the concern that such accommodation would create a system in which, quote, each conscience is a law unto itself, close quote, The legislature may, if it chooses, write specific accommodations into the law. But in the absence of explicit provisions, individuals may not claim exemption from the law as a matter of moral and constitutional right. The principled holding of this case suggests to me that if Congress had not included religious exemptions in the Volstead Act, neither Catholics nor Jews would have had a valid First Amendment claim against it, at least as Justice Scalia and the majority of the Supreme Court understand the First Amendment. Now, I have long argued that Scalia's opinion was deeply misguided. I know that others on this panel strongly disagree. Nonetheless, I believe it to be the case that the court has not overruled Smith in the more than 2 decades since it was handed down. Correct me if I'm wrong. The reactions that this case sparked, not only the Religious Freedom Restoration Act of 1993, in which I participated as the religious point person in the Clinton White House that year, and the Religious Land Use and Institutionalized Persons Act of 2000, but also a welter of judicial decisions at various levels of the federal system, testified to the unresolved debate over the limits of conscience-based claims against legislation that promotes general public purposes. Now, in the 5 minutes that I have left, let me go into this a little bit more deeply. While religious free exercise is one of our most cherished rights, it is far from absolute, even in core matters of worship. Free exercise doesn't encompass the right to conduct a noisy revival meeting at 2 a.m. in a residential neighborhood. Nor would anyone seriously argue that the claims of religious free exercise extend to human sacrifice, as opposed to animal sacrifice, which does, according to the Supreme Court, enjoy First Amendment protection. When I was in the White House, delegations of Christian scientists repeatedly petitioned me for relief from the health care requirements of the Federal Child Abuse and Protection Act. Although I listened very sympathetically, I could give them no satisfaction. And as many of you know, in the decades after the Civil War, the Mormon Church was hounded literally into legal extinction until it capitulated and abandoned a core tenet of its religious practice. I turn now to the current dispute between the Catholic bishops and the Obama administration over the scope of the Affordable Care Act, popularly known as Obamacare. You've already heard a bit about this. When civil society institutions, religious as well as secular, are intertwined with public programs, government will always attach conditions, some of which may be at odds with particular faiths. There is room for argument about the legitimacy of specific requirements, and some legal scholars have developed a theory of unconstitutional conditions with which I have considerable sympathy. The Church could try to press the case that various regulations of the administration breach these limits, or it could argue that the administration's decision violates RFRA, the Religious Freedom Restoration Act. But the bishops do their case no favor by framing the Affordable Care Act's requirements as a straightforward violation of religious liberty. There are 2 cases to consider. First, when the Church receives Caesar's money, that transfer does not mean that it ipso facto becomes God's money. It may very well be that Caesar should refrain from attaching conditions to the receipt of public funds, conditions that discourage the widest possible participation in programs that advance the common good. That is my position. But for better or worse, that is Caesar's decision. It is then up to civil society institutions to decide whether Caesar's conditions are too onerous to bear. Now, for the second case, and the one closer to the one before us, with the Church and the Affordable Care Act, non-governmental institutions are usually allowed to pursue their chosen course when they use their own resources, usually, but not always. For example, according to federal law, no agency can refuse to authorize a prospective adoption because it objects to placements of children across racial or ethnic lines. This is not a condition imposed pursuant to the receipt of funds. It is rather a per se civil rights provision, whether or not money changes hands. Since 1983, moreover, when the Supreme Court handed down its decision in the Bob Jones case, Federal law has allowed the IRS to withdraw tax-exempt status from any institution found to be practicing racial discrimination. In that decision, signed by fully 8 justices, the court ruled that institutions, including religious institutions seeking tax exemption, must not only serve public purposes, but must do so in ways that are not contrary to public policy and that are not grossly at odds with what the court called the, quote, common community conscience. I offer these remarks as a political theorist and policy analyst who has long argued for a robust interpretation of freedom of association and for maximum feasible accommodation of faith-based claims. If I had been in the Obama White House, I would have argued vehemently for an interpretation of the Affordable Care Act very different from the one the administration eventually chose. But having said this, the issue in my judgment is not one of second-class citizenship for religious believers in faith-based institutions. It is rather how best to interpret and apply our shared tradition of constitutional citizenship, a dispute that, as we've already seen, scrambles the partisan and ideological divisions that dominate the current political scene. Thank you.
First, John, I want to thank you for having this event and this dialogue, and it's certainly an honor to be on this panel with such a distinguished group of colleagues. And let me just address a couple of issues and then get into a specific analysis. One, and I appreciate, Professor, what you're saying, but we don't, we live in a republic. We don't have a Caesar and we don't have an emperor. It's a different form of government, and I don't want to get, it sounds like we're all getting into the HHS mandate, and I don't want to spend more time on it than necessary, but I think this is a significant encroachment on religious liberty. I think the Obama administration was aware of that, and that's why they ultimately gave way to the exemption for churches, but that, in my view, did not go far enough. But I also want to put it in context. While there are constantly religious liberty issues in the United States since our very founding that are significant, and sometimes religious practices are under attack. I mean, that's kind of the title of what I've written. We do live in a country that does allow broad-based religious freedom. And I think we've got to recognize, if you look at our system of government and the Supreme Court cases that have come down, and the cases that have been litigated even in the lower courts, we do recognize a great deal of religious freedom. I think we have to be vigilant to protect those. But we do have a great deal of religious freedom. However, the mandate that has been put forward by HHS, I do think, agreeing with Dr. Land, that this is one of the greatest attacks on religious freedom that our country's ever seen. To tell the Catholic Church to violate a core principle of their doctrine and faith in order to take federal funds that are utilized to serve communities that are significantly served by Catholic institutions, I think was a mistake politically, was incorrect constitutionally, and is bad public policy. And it's bad public policy because it wasn't necessary. It wasn't advancing a position that was constitutionally required. It became a policy decision of the White House, and I think it was incorrect. But I also want to say this, that we do have, as I mentioned, a great deal of religious freedom here. And I think we have to be cognizant of that. I've had the privilege of working on a number of cases at the Supreme Court of the United States involving religious freedom, and haven't won them all, but a vast majority of them, the courts have ruled in our favor, and generally overwhelmingly. It's interesting, talking about, Dr. Lehman was talking about 9-0. We had a case not too long ago involving a Ten Commandments monument in Utah. You mentioned the Mormon situation and the 1850s and 60s and what they were faced with on the religious freedom issue. And there was a Ten Commandments monument in a town called Pleasant Grove, and it was a monument that had been put in place in the 1950s, and it was the Ten Commandment monuments from the Fraternal Order of Eagles. I think that we calculated 6,000 of these around the United States, and there was all kinds of reasons they were placed there. I think mostly it was to promote a movie at the time that was called The Ten Commandments. And in fact, Charlton Heston came to a number of these events and a number of these dedications. But nevertheless, this Ten Commandment monument had been there. The Supreme Court had dealt with 2 Ten Commandment cases in a couple of terms previously, one of which involved the Fraternal Order of Eagles monument, which they said was constitutional. And this was a new challenge. And the challenge here was, could a city that had accepted this monument as part of their heritage, because for the members of the LDS Church, the Ten Commandments play a very significant role in how they view their doctrine, their history, their quest for religious freedom. All of this is part of who they are. So they took this Ten Commandment monument, it's placed in Pioneer Park, and a group comes in called Summum, S-U-M-M-U-M. And it was a new religion, certainly entitled to free exercise rights, there's about 20 members or so. And instead of the Ten Commandments, they had the 7 aphorisms. And I won't go into the aphorisms, but I would just say they were not the Ten Commandments. Everybody was kind of chuckling about the case until it wound up, guess where? At the Supreme Court of the United States. And the question was, could the city take that Ten Commandment monument and refuse to take the monument from Summum? And this put a lot of lawyers that deal with religious freedom in a kind of a quandary of what's the right answer. And to me, it was never that complicated. I represented the city. Of course, when you're counsel to the city, you're going to represent their interests zealously. But the position I advocated there was one that I thought made absolute sense. They did not raise, by the way, an Establishment Clause issue, which would have not been successful anyways, because there was a previous case from the Supreme Court in the Van Orden case where Justice Breyer became the decisive vote, and it concluded that those monuments were constitutional. But they made this free speech claim, and I'm a lawyer that's argued a lot of free speech. Religion is free speech. I've always been concerned about the free exercise litigation for precisely the reason Dr. Land said it. It's never worked out too well for the religious practitioner, and we, back in the 80s, started dealing with more of these religion cases as speech cases with good success, and generally overwhelming success at the Supreme Court. But this case wound its way up, and there it is at the Supreme Court of the United States, and the argument is, does the city have to, can they be required to take the competing monument? And, the Supreme Court, and Professor Hamilton clerked for Justice O'Connor, who's written a lot of the religion clause opinions, a lot of our religion clause opinions, a lot of cases I've had. And these are cases that, one thing when you argue a religion case at the Supreme Court of the United States, you don't have to be worried about will you be asked questions. You're going to get a lot of questions. And we got a lot of questions, but I use this example. When the government is speaking, which they did when the United States accepted, for instance, the Statue of Liberty, if a competing group at Liberty Park in Staten Island in New York wanted to place a competing monument to the Statue of Liberty, say the Statue of Tyranny, would New York or the United States government be compelled to take it? Well, the answer seems obviously no. In New York, where there is this, I'm a bit of a Beatle fan, so I know the intricacies of all these statues and monuments related to this particular event. There's an area called Strawberry Fields. And there's this beautiful mosaic of Imagine that was given by it's the Imagine No Religion of all ironies in the song. But this was given by citizens in Japan to New York to commemorate John Lennon's life and ultimately his tragic death. Would New York have been required to place next to that monument under some kind of speech or religion claim a monument to the assassin of John Lennon? Well, the answer is no. By the way, I think I have the only Supreme Court opinion where the entire lyrics to a Beatles song is footnoted, which I was going to send to Yoko Ono, but I decided since I still hold her personally responsible for the breakup of the Beatles, I wanted to. But nevertheless, when you look at the religion cases in the context from a speech perspective, it's very different. You've got a clash right now that's going on where the speech-type free religion cases, whether it's the gospel tracts being handed out in a public arena or the valedictorian that wants to include a biblical reference in their speech, generally those cases and successfully from my perspective, they're not even litigated that often, occasionally they are. But there was I think the best bookend on that was a case that actually Professor Hamilton was clerking for Justice O'Connor at the time, was the Mergens case, the Bible Club case. I'm be very cognizant of my time here. And that case involved religious expression of students that wanted to form a Bible club in schools. There was an act of Congress called the Equal Access Act, which had wide bipartisan support. Believe it or not, the religion cases used to have wide bipartisan support, and then the religion issues. And this particular case had wide bipartisan support, but it wound its way up to the Supreme Court of the United States again, did the act which allowed these Bible clubs to meet along with a chess club or Young Democrats club or Young Republican club or Young Libertarian club or whatever. Did that violate church-state separation, the Establishment Clause? And 8 justices of the Supreme Court said it did not. 9 justices, by the way, said that monument, the Ten Commandment monuments can stay and they didn't have to take the Summum monument. So these cases are winnable, depending on which way they are presented. The HHS cases, I come back to that, though, present a very different dynamic. Well, I think if I look at it from the perspective of the way we've litigated cases, I mean, it's hard for me to believe that the government of the United States can condition a position to the Catholic Church that is so contrary to their teaching and doctrine that they'd have to pay penalties or forego funding. Funding that's primarily given to neighborhoods in desperate need. I think, again, I'll end with this, is not only short-sighted, constitutionally problematic for the government, and I think if there's a free exercise clause case, that's the one, but also really bad policy to penalize these institutions that are trying to do good with this, as if the price of entering the marketplace of idea is that you surrender your religious values and religious teachings. And I think the government, who could have gone the other way on this, made a real mistake. I'm sure there'll be others that disagree with me on this. I know there are, but I think this is going to be a fundamental fight, and that's why you're seeing 20 cases in court right now. By the way, last point. We've had Republican nominees, Republican judicial nominees that have become judges rule that the HHS mandate is constitutional. We've had Democratic nominees that became judges that have said it's unconstitutional. These, kind of like the Affordable Care Act, they're not necessarily following any kind of predictable party line here. It's going to be important litigation, and I think this is going to be the great challenge ahead, because if it succeeds, that the government could do this, I shudder to think where it can end up. Thank you.
Well, I feel like I should issue the following, blanket apology before I get started disagreeing with everything that's just been said. Just to let you know, I am a lifelong Republican, raised by Republicans, and I actually won the RFRA case on one of the most effective states' rights theories that's taken effect at the Supreme Court. And I crafted that theory, and I've been a states' rights advocate for a long time. But it was my experience with the Bernie case and the Religious Freedom Restoration Act that taught me what really happens with respect to religion in the United States and where we are right now politically on these issues. And with great deference and admiration for our three previous speakers, I have to disagree. What I'd like to talk to you about is child sex abuse first. And I want you to get a sense of where the reality is of religion and politics, and then I'll talk about the HHS mandate. The reality is this. 1 in 4 girls is sexually abused, 1 in 5 boys. We now know that there's been a cover-up of gigantic proportions in the Catholic Church, in the Latter-day Saints, horrendous abuse in the fundamentalist Mormons. There have been problems in the Baptist organizations. Jehovah's Witnesses lost a verdict in California recently, $27 million. It's a very serious problem of religious organizations not doing what was necessary to protect kids and instead imperiling children while they protect their clergy. Just a fact. I mean, if you read the paper, you know that's true. But you also know what's happened at Penn State and Syracuse and the Citadel and the Boy Scouts and many other institutions. So it's a society-wide problem. I'm not picking on religious groups, it's just they happen to have the problem too. But right now, the single largest barrier to any victim being able to go to court in almost every state is the statute of limitations, just a deadline. That's it. And I'm talking about meritorious cases. It's very rare you find a frivolous case involving child sex abuse that's documented in hundreds of studies. People just don't make up being sexually abused as a child. They make up slip and falls, they make up all sorts of other awful things, but we're talking about meritorious cases here. And the statute of limitations are keeping the vast majority of victims, the vast majority, millions of victims out of court. So that the victims movement has, over the last 10 years, worked to try to open up the statute of limitations, not to make any other changes, just the statute of limitations. That has been the only thing on the agenda. It has passed in some states. In California, it's currently in place in Hawaii, where a victim who was abused 30 years ago can now go forward. Who is the primary opponent to statute of limitations reform for child sex abuse victims? It's the Catholic Conference in each state. They are spending millions, and I'm not exaggerating, across the United States of their parishioners' money to stop victims from going to court. That's reality. That's the play. And how does that play work? Well, it works because our elected representatives defer to bishops when they ask for a lot. They also defer to Christian Scientists when they ask for exemptions for medical neglect in the vast majority of the states. But my point is this. It's very easy for those on the side of maximum religious liberty to think that we do a good thing when we defer to religious organizations and we don't ask hard questions. But if we don't ask hard questions, the vulnerable get hurt. And right now in the United States, I can tell you that the Catholic bishops are lobbying against child sex abuse victims, and not one religious organization, except one, have come to the side of the victims. The only group to come to the side of the victims is the National Black Church Initiative. That's it. All of the other religious groups have been silent, supporting the bishops by not saying to their elected representatives, you really should let those kids go to court, even though they're now adults. And why? Because the cost of child sex abuse in this society is borne by the government. It's not being borne by the institutions because we have immunized the institutions with very nice statutes of limitations. So these victims are, most of them, addicts, difficult lives, underperformance in the economic sphere that is stunning. And who's paying for it? We are, because as dysfunctional as they are, the government's paying for their health care, not the institutions that created the conditions for the abuse. So, in my view, the biggest challenge, the biggest question about what would Jesus do right now is child sex abuse. And in the United States, we have an administration that sided with the Holy See to try to get the Supreme Court to reverse a case that was going to make the Holy See liable for the cover-up. Politicians in the United States right now think that you want them to do whatever the religious leaders want them to do. And that, I think, is the heart of corruption, and that is religious liberty. It is a misunderstanding of religious liberty. It's deference. And mindless deference to humans is always a problem. But let me go on to a different topic, and that is religious land use. When the Religious Freedom Restoration Act was held unconstitutional on separation of powers and federalism grounds and a violation of the amendment procedures of the Constitution, immediately the religious advocates went right back to Congress and said, quick, reenact it to apply to federal law. So it was held unconstitutional as to all laws if you read the decision and not the press releases. Congress obeyed the religious lobbyists and reenacted it. So RFRA now applies to federal law. All well and good, it hasn't had that much of an effect. I'm not going to talk about that. Then our LUPA was passed, the Religious Land Use and Institutionalized Persons Act. Our LUPA is a law that says that if you are a religious land use developer, that you have special privileges to trump local zoning laws. And I don't want to spend a lot of time on it, but what I can tell you is true is that the victims of our LUPA are neighbors of ambitious religious projects. And the reason our LUPA has the teeth it does is because the government included an attorney's fees provision. So now any city that is trying to keep its land use plan or protect its neighbors is facing lawyers who say, you know, if you don't do what we tell you to do, frankly, we're going to get attorney's fees. We're going to get $5 million in attorney's fees. And you have to pay your own attorney's fees, and you have to pay the church's attorney's fees. So the financial weapon of attorney's fees is now making taxpayers pay in cases that are not meritorious. There's no religious discrimination. In fact, in a recent case in San Leandro, California, we have a case involving a minister who voluntarily crossed out in a land use agreement the contingency that said that he would not have to pay for the land if he didn't get the zoning. And he says, no, I don't need that contingency, I'll just go forward. That case was just settled. The city paid for the financial silliness of a minister who entered a land use deal no one would ever enter. That's where we are right now. We deal in a situation where there is such overreaching by religious entities in legislatures that we are not at equal poise. But I know I'm running out of time, so let me just quickly say two things. I think everybody needs to be careful when they read the Hosanna Tabor case. The court really says, look, it's been for 50 years in place in the lower courts that religious organizations get to choose their priests. And I can tell you, having gone to the oral argument and submitted an amicus brief on behalf of child sex abuse victims, that there's no question that Catholics will never have to hire a woman. Anybody losing sleep over that, it's absolutely clear. Everybody agrees one basic rule is that priests don't have to be women. And that's basically what the decision said. But what is not talked about by the religious lobbyists and leaders is that what does Hosanna Tabor really stand for? It stands for the constitutional right to discriminate against clergy based on gender, on race, and based on disability. So the case came down, and the woman who was fired had narcolepsy, and it was an American Disabilities Act case. And the church said that the problem was that she went to the court. She's supposed to listen to them, and that's all fine and good, but you need to understand the court's holding says that even if the religion doesn't require it, even if the religion doesn't require you to discriminate on the basis of race, the decision now protects all religious entities' ability to discriminate on the basis of race without inquiry by the courts. And finally, HHS, the HHS mandate. Well, I won't belabor it, except to say that my column on justia.com tomorrow will violently disagree with everything that's been said today. It's clearly constitutional. And the reason it's constitutional is this is the most extreme request ever made under free exercise. This is not a request that involves someone saying that I can't practice my religion. It's not a request that says that I can't believe what I want to believe. This is a request that says I should not have to put into a fungible pile of money that individuals who don't believe what I believe will use in ways that I disapprove of. This is the first free exercise challenge in which the religious believer is saying that he wants to be able to deter others from using money in ways that he disagrees with, and they're not his fellow believers. This is a commercial entity. In the case that was most recently decided, it's a commercial entity. And let me just close by saying Title VII forbids discrimination on the basis of religion. What these arguments are is the backdoor ability to get around that rule that you can't discriminate on the basis of religion. They want to favor their own religious fellow believers or deter non-believers from working for them so that the whole world will reflect their religious values. That is balkanization. And if you're not watching the Middle East or the Balkans, you should be, because that is a scary future. Thank you.
Before we get to questions from the audience, let's take 5 minutes to see whether any panelists would like to make any remarks in response to what they've heard.
Well, let me just start by saying that I was a strong and vociferous opponent of the Smith decision, and I agree with Senator Day O'Connor's opinion, which, by the way, if you turned out the lights in the room, it would glow in the dark, in her criticism of Scalia's position, where they destroyed the compelling interest barrier and went to a merely reasonable one. And I think it was the worst decision by the Supreme Court in the religious freedom area in my lifetime. And I was born in 1946. And the Congress tried to rectify it, and the Supreme Court, having painted themselves into a corner, considered it and then applied a second coat. And let's remember, this is not a Republican-Democrat issue. I mean, Scalia, if he's anything, he's a Republican. He's dead wrong on this issue. And it opened the way for a great deal of abuse because it left, you had, instead of a high hurdle of a compelling state interest, now all you have is a reasonable interest. And the zoning thing cuts both ways. We have been involved in cases where zoning commissions have told people that couldn't have Bible studies in their own homes. And that's where I lose my commitment to states' rights. When the state Supreme Court in Connecticut says that a couple in Danbury, by the way, interesting, it was in Danbury, Massachusetts, rather famous because of Thomas Jefferson's letter to the Baptists of Danbury, that a couple could not have a Bible study in their own home because it caused parking problems to the neighbors. They lost in state court, and they won at the Supreme in federal court. Let me be very clear here. I generally believe in the devolution of power to the states, but there are some absolutely sacred principles that are in the Bill of Rights that we cannot leave to the demographic anomalies of the states. It must be decided federally, and it must be decided by the Constitution. And one of those is the free exercise of religion, and that includes the right to have a Bible study in your home. It also includes not to have some dipwit zoning commission telling you how many services you can have on Sunday morning and what the maximum number of people you can have and when you can have them, because it might cause traffic congestion on Sunday. We've had those cases. Not in Alabama. I'm not worried about free exercise in Alabama, but in Oregon, in Washington State, and in California. And so the free exercise, I think the free exercise clause is absolutely essential and is being violated routinely by zoning commissions, and I think the Bernie zoning commission did it as well. Basically what the Supreme Court said in that decision was the bishop and the Catholic Church was arguing, we are not a plumbing supply company. We are not a used car dealership. We have protections under the Constitution that are not given to businesses. And when you have, they had a right to expand their church.
Anyone else? All right, let's get to questions from the audience. Now, here's the drill. When I recognize you, if you would please wait until you are handed a microphone, and then if you would announce who you are and any affiliation you have. And although we will be happy to consider you as a future panelist at a Heritage event, I'd ask that at least on this occasion you restrict yourselves to asking a question rather than making a speech. Anybody want to ask a question? Any hands? Got in the back.
Nab Nasworth with the Christian Post. My question is for Dr. Galston. Your remarks surprised me because everything you said leading up to the HHS mandate made me think that you were going to be critical of the Obama administration, because you talked about the exemption in the Volstead Act and RFRA and RLUIPA. And then, and I know from reading your columns, you don't shy away from criticizing Democrats when you feel it's proper. But as you know, a lot of the controversy has to do with the exemption, how the exemption is written, and so you say it's for the common good, but there is an exemption. So for some people, it's okay, that it not be for the common good. So why not expand that exemption? Why not include, Christian schools, Bread for the World, things like that?
Well, I had thought I made it clear, but clearly I did not. I said in my peroration that had I been in the White House, I would have argued vociferously for a much broader exemption than the one the Obama administration ultimately settled on. And let me just go through the triad quickly. Was it a political mistake? Sure was, Jay. Was it, from my standpoint, bad public policy? Again, check. The area where I'm not so sure, and I wouldn't mind seeing it tested, is whether it rises to the level of a constitutional violation. And the invocation of the phrase second-class citizenship has to be understood. It's refracted through the prism of the American idea of constitutional citizenship. And I have my own views as to what constitutional citizenship amounts to in these questions that would lead me straight to the conclusion, that this is a violation of religious free exercise. That is my position. Whether that will be the court's position is a different matter altogether. So I fear that you've misunderstood me. The question is really very much one of how the Constitution is to be interpreted, and as we know, how the Constitution is to be interpreted is not a matter of blank slate sola scriptura reasoning. It's much more Catholic and Jewish, refracted through a tradition of interpretation, of which the Smith decision is a very important contemporary part. That's just a fact. And so I'm not at all confident that the court would agree with my theoretically driven interpretation of what I think the appropriate interpretation of constitutional citizenship is.
Right there.
Hi, Matt Bowman with Alliance Defending Freedom. There's been one federal district judge to issue a preliminary injunction against the HHS mandate and one to dismiss a lawsuit. Are we going to have a circuit split, and is this going to go to Supreme Court? And how's that court going to rule in light of the unanimous decision in the O Centro Espirita case on the RFRA challenge?
I think these cases are going to wind their way up to the Supreme Court. I don't think it's going to be this term. I would be surprised if it is, because I think the court's going to want to see how it develops, and in light of that, I think you're probably looking a couple of years before you see the cases actually reach that level. And it's also going to depend on the nature of the split, and it's going to depend on the makeup of the Supreme Court at the time. I was never, the reason I'm a lawyer is I was not a doctor, a medical doctor, is I wasn't a particularly good math student, but the one thing I can do is count to 4 for certiorari and 5 to get the opinion you go your way. And I think right now it'd be close. But the court could be very different in 2 years when the case comes up. So I think, yes, these cases are destined that way. Also is dependent upon the election. Because if the election, if there was to be a change in the White House, it's probable that a President Romney would get rid of those regulations, and it's all it is, the regulations.
Right.
They can be regulatorily undone very quickly. If President Obama wins re-election, it'll stay, and I think that's where the litigation goes. So some of this litigation is dependent upon the election and the scope of it.
And if I could just add here, let's always understand, we respect and agree to, abide by, unless we want to practice civil disobedience and pay the consequences, the decisions of the Supreme Court. But let's do understand that all they can do is give us 9 lawyers' opinion about what's legal and illegal, not an opinion about what's right or wrong. And we reserve our right to say that they were wrong, both legally and morally. And the great thing about America is, if you lose this one, you can always come back the next election and make a better argument and win. And the same thing's true with the court. Frankly, I think Senator Day O'Connor nailed it that the Smith decision was a catastrophe for religious freedom. And it was done by a majority of a court appointed by Republicans. So this is an issue that cuts across partisan lines and across a lot of other lines as well.
Let me just say one, Smith actually says it's a majority, it's not just Scalia all by himself.
No, he just wrote it.
But it's a whole court that says that the vast majority of their cases have applied the rule that neutral, generally applicable laws govern. It's actually accurate. It's true. If you go back over the cases, that's actually what the case has said. But more interestingly, I obtained the justices' papers from all of the conferences involving Smith, and both Smith 1 and Smith 2, and wrote an article in the Cardozo Law Review, which you might find interesting historically, which is that the Supreme Court did not think at all that it was doing anything overturning its previous cases. And in fact, this was a case of first impression. So I think I don't want any of you to think that I think Smith is wrongly decided, because I certainly don't. But the case that's going to determine the HHS mandate, I think, is the one that's already been in place for many years. That's United States v. Lee, which held that the Amish can be required, even though it is in direct violation of their religious beliefs, to pay into Social Security taxes. The Amish do not believe in Social Security because they believe in the obligation to take care of each other as they become elderly, and that it's wrong to have the government interfere with that relationship. The court in Lee said that that was not a violation of the Free Exercise Clause, and I think that this violation, if it were one, is so much more attenuated than the direct payment into Social Security funds. This is a payment into a fund which then the money is used by an independent agent, the employee, using their own religious beliefs in consultation with the doctor. And so I think United States v. Lee has to be overruled, and that's not going to happen in order for this case to come out differently.
Bill, you had something
I
you
think there's an overriding issue that I can't get outside the context of the HHS mandate for a moment on religious liberty generally, and that was, since we've been invoking Justice O'Connor's name so frequently, and that was Justice O'Connor's concurring opinion in the Newdow case involving the Pledge of Allegiance, where she said it would be ironic indeed if a nation founded by religious refugees would sever the ties that bind it to this very day. And then she talks about that's why we have religious sentiment statements about a creator. We have our oath that has reference to God. We have songs and pledges of allegiance and one nation under God, in her view, was not unconstitutional. I think we have to be cognizant of the fact that those end up being the easy cases. Those are not the complex cases. Those are those kind of cases. When I say easy, it doesn't mean you're going to win them or lose them. It's just that there's more of a consistency. When you get into funding, which is how the HHS mandate will be presented by those that think it's constitutional as a funding case, to those of us that think it's unconstitutional, it is going to be a free exercise case. That is where these are much more difficult, following up on what Matt's saying, much more difficult to predict where they're going to go. We're litigating some of those, so I can't get into specifics on strategy and whatnot, obviously, but there's a lot of moving parts with all of this in the months and maybe even just weeks ahead.
Bill, you want to jump in?
Yeah, and, I think we're all very fortunate that seated to my left, but to my stage right, are two people, two veterans who have litigated Supreme Court cases in this area. And in addition, Jay, I don't know whether you're a law professor, but I certainly know that
From time to time.
from time to time, and I certainly know that Professor Hamilton is. Just out of curiosity, may I ask the two of you to comment on my hypothetical? Because, I thought that the parallel between sacramental wine and sacramental peyote was reasonably good. We all know why the Catholic Church and the Jewish community were excluded, and I think we also know why the politics of excluding something central to a Native American religious practice, practiced by very few, and, sort of religion outside the mainstream, might not have received the same kind of legislative deference. But assume for a minute that the politics hadn't obtained in 1919 and sacramental wine had not been explicitly exempted. What do you think?
Well,
Is that a First Amendment issue?
Well, it would be for my family because we have a aggressive Seder. I will not say how many cups of wine, but we have a Seder.
I've already covered that.
And, okay, so you've covered that one. So I'll just leave that part at that. But I think it would have raised a significant First Amendment free exercise issue. And the Smith decision and the whole idea that it was because it was an illegal, if you read all of Smith and try and read a lot of the literature that's come around it, it's like next we'll be legalizing marijuana for uses in that context. And I think that was taking the peyote use from a Native American Indian ritual that had been around for, 350 or 400 years, and taking it way out of context. But again, predicting these is tough, but I think you raise a very, very valid point on that line on free exercise. We think, wine, that's normal. That's a lot of religions have that. Well, peyote, not many do. But the consequences of the utilization of it, for instance, if you used too much wine or too much peyote, I suspect, I would not know from personal basis, but you'd have the same health concerns, I would say. But that does not eliminate what I think would be a significant free exercise right.
Well, actually, in 1919, the controlling case was Reynolds. And in the Reynolds case, the Supreme Court said that a law that banned polygamy was enforceable against the Latter-day Saints, or a Latter-day Saints, Mr. Reynolds. And the court used the standard that it then reiterated in Braunfeld and then in a number of cases all the way up to Smith. And so I think it would not have been a winner. I'm sure someone would have brought it. I think what's interesting to note is how willing legislators are to provide these kinds of exemptions. At the time, Catholics did not have political power. They were some of the most discriminated against people in the United States, and they got this exemption. Why? Because, as the Smith opinion says, our legislators have been quite good on these issues. And I would point out in the Smith decision, they pointed to approvingly the states that had exemptions for the use of peyote. And following the Smith decision, there was a lot of publicity about RFRA needing to correct it, but in every state where there was a Native American presence, they enacted an exemption for the use of peyote. So Smith actually opened the door to an expansion of religious liberty through its own reasoning in the states. So, I think we have to be very careful about overgeneralizing on these issues, but also you've got to look at the legislators and legislatures to see what's really happening on the ground. There are a lot of exemptions you've never even dreamed of that are out there that you may not approve of, like no requirement to report child sex abuse if you're clergy in a number of cases, in a number of states. So,
I think we have time for one more, and I see a hand over here.
Thank you. I wanted to ask Bill Galston and anybody else who might want to comment about the
If you could just tell us who you are and what affiliation.
Oh, I'm sorry. Full disclosure, I'm Richard Dorflinger. I work for the Conference of Catholic Bishops. Let me take the human trafficking grant case, because that's a case where you would expect the government to have pretty broad discretion because of public program, public funds. But what they were requiring the Catholic agency to do, they said they would give strong preference to, quote, grantees that will offer all victims referral to medical providers who can provide or refer for provision of the full range of legally permissible gynecological and obstetric care. So if the Catholic agency was not being treated as a second-class citizen, why was it not treating believing Catholic doctors as second-class citizens? Because basically what they were being told by the government was they had to stop their previous practice of the previous 5 years of referring patients to, just a cross-section of doctors in the community, and instead had to send them for medical care, any medical care, only to doctors who are willing to provide elective abortions or facilitate them, which even violates the federal government's own standards in the Hyde Amendment against elective abortions except life of the mother and rape and incest. So you have the
Let's get
church.
to the question.
Yeah, well, why is that not saying a doctor who won't perform and refer for abortions is a second-class doctor, if not a second-class citizen?
Well, first of all, I think that's a fair question, and I cannot masquerade as an expert in the particular area that you raised. I would only say this, that the government is in the business of establishing general public policy. General public policy, by its very nature, is not and cannot be neutral as between or among the different practices that it controls. And so the issue, it seems to me, is whether a general public standard that the government enunciates is one that it ought to enunciate. But any general public standard of that sort is going to affect different people under its purview differently. There is no neutral law. And a lot of my political theory brethren, have spent decades looking for neutrality, and it is not to be found. So the real debate is the substance. And what I resist is the language of first-class and second-class citizenship, because I think that displaces the discussion from where it belongs to someplace else. But, once we got down to the particulars, I might very well agree with you on the particulars. It's the description we're arguing about.
Anything else? Thank you all for coming. Please join me in thanking our panelists.